That would be bad. All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Well, thank you and welcome. Good afternoon. Welcome to the North Carolina Court of Appeals. I am Judge Toby Hampson. To my right is Judge Jeff Carpenter. To my left is Judge Darren Jackson. We do have two cases on the calendar for argument this afternoon. Just as a sort of brief matter of housekeeping, we'll take a slight pause. We'll remain on the bench, but in order to switch over some of the recording, we'll take a slight pause in between the two cases and allow everybody to get reset. After the second argument, we will go into recess, after which we'll reconvene in order to return in ceremonial session in order to hear a motion for the admission of a new attorney, and presuming without deciding that that motion is allowed, we'll then administer the oath of an attorney. So if the parties in the first case are ready, I have it as State v. Monroe. And if we're ready, we'll hear from the appellant.
May it please the court, I'm Michael Kesterline from Asheville. I'm here on behalf of Osmond Monroe, the appellant in this matter. I would like to reserve 6 minutes for a rebuttal. Mr. Monroe is the appellant in this matter. He was convicted of second-degree murder out of the Superior Court in Wake County in early January of 2020. The facts of this case go back to the Wake County case, shooting that occurred in Raleigh in October of 2017. Mr. Monroe and a couple of friends of his had gone to a party. So at the party, one of the friends encountered another young man who was at the party with a group of his friends. There was a fight. Later that evening, Mr. Monroe and his friend, Mr. Sanchez, went out, and there was a confrontation in a parking lot with Mr. Monroe, his friend, Lazarus Hone, and two of his friends. There was a struggle over a firearm that Mr. Monroe had with him, .40 caliber Smith & Wesson. During the struggle, a gun discharged. Lazarus Hone was killed. Case was tried in January of 2020 here in Wake County in front of Judge Holt. The case went to the jury on first-degree murder, on second-degree murder, and on manslaughter. On the second-degree murder count, the judge instructed the jury and gave them a special verdict form dealing with 3 theories of malice. The jury came back and found guilt of second-degree murder and found all 3 theories of malice: the intent element, the ill will and spite, ill will, hatred element, which was A, the intent degree of malice, which is B, and C, which is the commonly known as depraved heart, or an inherently dangerous activity engaged in with recklessness that might endanger someone's life.
And so I recognize that your argument is focused primarily on the sentencing aspect of it, but sort of focusing in on the verdict, because I think it's central to your argument. In at least, you're not contending that is an inconsistent verdict.
Well, we haven't argued an inconsistent verdict in the sense that Mumford addresses that issue. We're talking about, I guess we're saying an ambiguous verdict or an ambiguous statute, but we have a situation where when this second-degree murder statute was changed in 2012, it was not clear what to do in a situation, what the appropriate sentencing is, because depending on the theory of malice, second-degree murder can be sentenced as a B1 felony or as a B2 felony, and that's what happened here. Well, we have a jury returns a verdict finding all 3 theories of malice. One of those theories of malice, the ill will, the depraved heart, inherently dangerous, reckless malice, which was C on the verdict sheet here, calls for a B2 sentence, whereas the other 2 call for a B1 sentence. And that is a problem. Now, this court addressed that statute in a case, State v. Mosley, in 2017. In that case, the evidence would have supported different theories of malice, but the case went with an unspecified verdict, no requirement, no instructions on a jury finding particular theories. And when the case came before this court said it needs to be remanded for resentencing as a B2 because we're not going to think about what the jury meant. And the court then, in the very end of that opinion, gave some specific instructions about how a superior court judge should address a situation where the evidence might support the reckless, dangerous activity, the depraved heart first-degree, second-degree murder, and the traditional second-degree murder that we have, the ill will and the spite or the malice and intent. And the court said, give the jury a special verdict form, which is exactly what Judge Holt did in this case. They talked about it at some length in the charge conference, and she crafted a verdict sheet that provides for the jury to find guilty of second-degree murder, and then A, and then a B, and then a C. The jury comes back and finds all 3. So the special, following the instructions of this court, doesn't really solve the problem that was created by the amendment of the statute. But it does do exactly what Mosley said. It follows the directions of this court, but the statute itself does not resolve what the appropriate punishment is in a situation where the evidence might support one or the other. The language of the statute says second-degree murder shall be sentenced as a B1 felony, except if it's sentenced as a B2 felony. And that's the problem we have. Now, we have the Mosley decision is in 2017. Last year in this court, in the case State v. Borum, this court addressed an issue very much like what we have here, where a superior court judge followed the instruction and gave the jury a verdict sheet that required them to find the theories of malice. Now, that panel of this court in November of last year decided that the Mosley decision compelled them to rule that the case needed to be remanded for resentencing as a B2 felony. And the state has filed a PDR. The PDR in that case is pending before the Supreme Court. They've not ruled on it yet, so we We don't know their decision would be, but we think that our position is that the decision in Mosley compels the same as the decision in the unpublished case of Borum, which is that this case needs to be remanded because whether you call it an ambiguous statute leading to an ambiguous verdict or wherever you throw the word ambiguity, the problem is the same. We have a statute that when applied to a certain set of facts and a jury's determination of different theories of malice, the statute does not say what level of sentencing should be. And that makes a considerable difference. In this case, my client, Mr. Monroe, is a level 1 young man, no prior record, and he received a 240-month sentence. That's the top of the presumptive for a range for a B1 felony. As a B2 felony, the top of the presumptive range is 157 months, which is 13 years, I guess, 13 years and a month, as opposed to 20 years. The bottom of the mitigated range, the lowest possible sentence, is as low as 94 months. So it carries a difference in years, and it does matter, and we feel that the rule of lenity requires that that statute, that ambiguity be resolved in favor of the defendant as opposed to in favor of the state. What we have is, the rule of lenity is not, I don't think, some archaic concept long ago, but it's a concept our Supreme Court has used to resolve an ambiguity as recently as April of 2020 in the Conley case, which had to do with the unit of prosecution when a firearm on educational property, whether several guns meant one conviction or multiple convictions. But the rule of lenity remains a vital and appropriate tool for courts to resolve ambiguities in statutes that don't leave clarity about what the appropriate sentence should be or what the appropriate unit of prosecution should be. And we think that is the appropriate resolution in this case.
Well, as I understand it, the state has argued for perhaps a more narrow construction of the rule of lenity, such that it would only apply to the ambiguity of a statute, and it wouldn't necessarily apply to an ambiguous verdict or an inconsistent verdict argument.
Well, I recognize the state says that the statute's not ambiguous. The state cites Mosley for that. Says, I think their language is that this court has said the statute's not ambiguous. And the state says that we can say that the verdict's not ambiguous because the jury was given specific instructions. But whatever we call it, we still have a situation where we take the record on appeal in this case, we take the facts, we take the jury verdict, and we take the law, and there's no clarity about what to do. And the state contends, I think the thrust of the state's argument is that they don't cite any authority for this, is that somehow there's a merger, I think they say, akin to finding a greater and a lesser offense such that the B2 felony is merged into the B1. That's just their proposal of how this court should resolve that ambiguity. And I don't see any support for the court crafting merger of those. It's not an analysis where we lesser included. It really requires almost an entirely different way of looking at facts that somebody is, as opposed to acting intentionally or out of hatred or ill will, that they're acting recklessly. It's almost the opposite, but a jury can find that somebody's conduct might meet both criteria and they can return an appropriate verdict. The problem is that the legislature hasn't told the courts how to resolve that ambiguity. And that's the problem we have here. That's the problem that a panel of this court recognized in Mosley when they said this is some guidance about how to resolve it. That's a panel of court in Borum, panel of this court feeling that the Mosley decision compelled them to resolve it in favor of the defendant, and that's what we have here. I know the state thinks that it somehow is very clear cut that it reverts to the B1, but again, they would like to argue there's some merger there, but they don't cite any authority for that, or even another analogous case where one theory is merged into another by virtue of a jury finding both and one being greater than the other. And we think that that's simply asking this court to stretch the meaning of the law beyond what is there in order to resolve the discrepancy in favor of the state, as opposed to what we have traditionally for hundreds of years done, which resolve those discrepancies in favor of criminal defendants. And that is what the Supreme Court of our state in Conley, that's the principle that they applied to resolve that ambiguity. And again, I don't think that it's so, what you call the ambiguity, the state would like to say that it's not an ambiguous verdict, because we know what the jury wanted to do. They wanted to find all three, and it's not an ambiguous statute. Well, what is the problem? Why is there no clarity? And why can they cite to anything that says, can't they cite to anything that says there is clarity? And we don't think they've done that or advanced any authority. So this, I guess to some extent, that's a case where we now have facts that lead the court to have to resolve the issue that was left open by Mosley. And again, the Borum case, which they brought forward in their brief, which is unpublished decision, but it's pending before the Supreme Court, that suggests that the appropriate resolution when a jury finds all three, as dictated by Mosley, is to resolve the ambiguity in favor of the defendant.
Mr. Castellan, excuse me a second, but you don't dispute that your client was convicted of a B1 felony, is that correct?
Well, I think that the jury returned a verdict finding all three theories of malice. And we have the language of the statute that says, shall be sentenced as a B1 felony, except if he's to be sentenced as a B2.
Well, it says except if the malice used to reach the level of second-degree murder based on extreme indifference, depraved heart, right?
Yeah.
It says except. So, I mean, technically, above that, he met the first two different prongs of the way to be found convicted of B1 felony. Is that correct?
And I think that that's certainly what the record is and what the facts are. And but I don't think, I think it's a stretch and somewhat of an unfair stretch to say that we should treat it as if it's a included offense. It's not. It's under the Blockberger type analysis, or where we have a greater offense and a lesser offense. A defense lawyer could argue that, well, it's greater or lesser based upon that, and a jury has to decide.
And I agree with you that I think that Judge Holt followed the holding in Mosley correctly and did
Right.
what Mosley directed her to do. And it does, in this case in Borum, that this is at least twice this problem. So going forward, what would you recommend? I mean, how would the state ever be able to proceed on both the B1 and the B2 felony? What would be necessary to do in order to do that?
Well, I think that traditionally when our courts, remember the rule of lenity, I guess, has some roots in a separation of power theory. You know, a check by our courts on, I think it goes back to a check on the king's power to have people beheaded, but more recently a check of our courts on the legislature is that when we have an ambiguity, we have something that's unclear, we're going to resolve that in favor of the defendant. And if the legislature wants to correct that or change that, they can do that. They can say, in an event this way, and they can enact a change to that, rather than have the judges of the court go out and find some new doctrine, because we have an age-old rule for resolving ambiguities in statutes. And I think that would be the way. Until the legislature does change it, we say when a statute provides two possible alternatives for sentencing, we follow the less sentence until the legislature says otherwise. And I think that would be the appropriate proposal under any theory of judicial interpretation of statutes consistent with the age-old principles that we have in interpreting statutes.
Thank you.
And the final thing I'd like to say, I think that there aren't cases where I could identify any case where an ambiguity in how to apply a sentence has been resolved. I think generally, though, if we follow what the panel in Borum had said, they felt constrained by Mosley to adopt the lesser sentence. I think that where we have taken, we generally don't think that we're going to increase a penalty based upon a legislature leaving some unresolved issue in the statute. So what we have is a situation, again, where a B2 sentence seems to be warranted by this case. That's what a jury found, and isn't required to make an either-or selection. And again, if we're going to say that a jury should have been, then perhaps we needed to know that at the point that the lawyers were arguing about what the appropriate verdict was, and not sometime after the fact. And that's exactly what Mosley says. Is Mosley, again, is a case where the evidence supports different theories, and the Mosley court, we're not going to speculate about what a jury should mean. And we don't know if a jury had to pick one or the other, what they would do. And we don't know if a defense attorney at trial was arguing that we think that the B2 is the appropriate verdict as opposed to the B1 second-degree murder. That would be a different thing. But to go at this point after the trial, the only appropriate thing to do is to sentence him as the B2 felony. And if there's no other questions, I'll just reserve the remaining time for rebuttal.
Mr. Grisland, you said something that I picked up on there. You said that the jury found the defendant guilty of B2 felony, and that would be the appropriate sentence to impose. And that's what we're talking about, is sentencing.
Yes.
We're not talking about the substantive statute in regards to the offense described by the legislature. Right. We're talking about treatment post-conviction.
Yes.
The jury, in this case, also found the defendant guilty of a B1.
Yes.
So does the logic just work one way? Your logic is he was convicted of B2, therefore he should be sentenced to B2. Is it a one-way street? Well,
it's the same. I think the issue why we talk about the rule of lenity, why Conley talks about it. Conley, a jury came back and convicted him of 5 counts of something, right. And the Supreme Court says, well, the statute doesn't say what to do. If the statute leaves something ambiguous, we resolve that in favor of the defendant.
The language in Conley used by the legislature was any gun.
Right.
And they determined that any gun
right.
applicable to all 5, or was any gun that
so that's a different, admittedly, a different type of ambiguity. But the logic of the rule of lenity, again, it's an age-old principle that says the logic does only work one way when a statute is not clear about what to do. And what we have here, we have a problem that was recognized by this court in Mosley.
The issue at Mosley was it was presented to the jury, and the jury determined there was malice and it was second-degree murder, but there was no special verdict form presented whereby the court could tell which theory of malice the jury used to get there.
And so then the court recognized that, well, if there's more than one possible theory, the court in Mosley didn't say go back and have a new trial. Court in Mosley said, go back and sentence him as a B2.
Right.
Resolve that discrepancy in favor of the defendant.
But we have that's not the discrepancy that we have here, as you astutely mentioned early on. We know what the jury thought. The jury found beyond a reasonable doubt. Presumably, the jury followed the instructions, found beyond a reasonable doubt as to all three theories. And the question that we're faced with is what to do. I think Judge Jackson asked you,
Well,
we've had this come up 2 times now, how to fix it, and I'm going to throw you a bone. Maybe treat it like a lesser included offense. If you find this or this, then don't answer the third.
well, that might be an appropriate remedy going forward, but it's certainly not fair to apply that rationale at this point on a trial that's already happened. And that wasn't what the state didn't argue that in the charge conference of this case. That is not the analysis applied by Mosley. The court in Mosley could have done that. Could have said, going forward, we should treat it as a lesser included. That's not the analysis the Borum panel applied to it. And that I recognize that perhaps would be a way to resolve this as some sort of lesser degree or some sort of merger. I think it can't really be a lesser included because it doesn't really fall within the block ballot.
The closest thing to a merger argument that I could come up with is a first degree under premeditation and deliberation or felony murder rule. You could be found guilty of both, but there's just one murder.
There's just one murder. And so we could suggest a merger idea going forward, but it wouldn't be fair or appropriate to now apply this retroactively to the facts of this case. And again, the problem perhaps is that the panel of the Court of Appeals, which set out some direction to the trial courts, that when those directions were followed, it didn't really resolve the problem that has now come up twice, which is what do we do if a jury finds both? In the state, I guess the logic of the state is that if we are thinking, well, lesser included, something to that effect, that we construe that for the state. But I think that the rule of lenity and age-old doctrine, principle of statutory construction says resolve it the other way.
Thank you, sir.
Thank you.
Thank you. If there are no further questions from the panel, we'll let you reserve the remainder of your time for rebuttal. We'll hear from the state.
You want it back? Good afternoon. May it please the court. My name is Stephen Armstrong. I am a Special Deputy Attorney General for the Transportation Division. When I was here 4 years ago, and I argued Mosley, I was an assistant AG, and it was a transportation section, so we've moved up in 4 years. Mosley, when I argued it, basic facts, boyfriend, girlfriend having a fight, boyfriend moves out, is moving out, his clothes in one hand, his gun in his other hand, a rifle. He keeps his finger on the trigger, no safety on. He tries to push past her. Defendant says, he testifies, the victim pulls the barrel toward herself. The gun discharges, she dies. So you have the defendant saying that he did not intentionally pull the trigger. It was the victim pulling the barrel, causing the gun to discharge. And that's relevant here because it's basically the same set of facts that the defendant here, he testifies that he is drunk, he's been drinking all day with his friends, and he's at this party, and during the fight over the gun, he is positive he did not pull the trigger. So that's where Mosley and this case are similar, that the defendant testifies in both. Defendant testifies that he did not pull the trigger. The facts are not in dispute here. About 99.9% of the facts are agreed. You have 2 sets of friends, 3 in each group. The victim and the defendant each has 2 friends. They go to this house party in North Raleigh. People are late teens, just graduated high school, early 20s. And there are several fights in this apartment. There's between 30 and 50 people in this apartment. There are several fights. The host of the party kicks everybody out. The victim, Mr. Hone, is involved in a fight by the front door against the defendant's friend, Mr. Benitez. And in that fight, Mr. Hone's two friends join, so now it's 3 against 1 inside the apartment before everyone is kicked out. And Mr. Hone, he cuts his thumb during the fight. There's cell phone video of what happened in the parking lot, and that was shown to the jury. I have it on my cell phone. So now that everyone is kicked out of the house, defendant is approached by Mr. Benitez, who has been beaten up, and says, "Where were you? You should have had my back." So defendant now pulls out his gun, which is that stolen .40 caliber Smith & Wesson, and there's ballistics experts who testified that this gun had 3 types of safeties. It had a thumb safety, it has an internal block safety, and it had a trigger safety. And those safeties are important because one of the safeties didn't work, the internal block safety, but the other 2 safeties worked. So defendant is now in the parking lot, it's dark, walking up and down to groups of people, putting a gun to people's heads and their chest. Who beat up my friend? Who beat up my friend? Who beat up my friend? Finally, Hone comes up and says, "I did." And that's where Hone and the defendant are in a confrontation. The defendant is placing the gun to Hone's head, to his chest, and Hone is swatting the gun away, getting his blood from the fight on the gun, 3 parts of the gun, both sides and the back. And it was at that point where defendant testified that the gun discharged, but he's positive that his finger was not on the trigger at the time of the discharge. And the shot was a perfect kill shot. Took out a lung, took out his heart, took out his spine. And the ballistics, the coroner testified that there's no stippling on Hone, meaning the shot was more than 2 to 3 feet away.
Well, is the state arguing that the evidence would not support depraved heart murder? Is that your argument here?
No, it's all 3, because we have to look at the case of the Supreme Court case of Arrington, which I'll get into. But when you go to the Borum case is the case that's on appeal to the Supreme Court. And that is the Black Lives Matter rally in Charlotte, where the defendant has his gun. He attempts to shoot at the police. The gun jams. He clears the jam and just randomly shoots and kills somebody. And that is the case that's now on appeal, whether that evidence is depraved heart, because it's a wild shot in the air versus a shot point blank. So in Borum, the jury found all 3, ill will, intentional, and depraved heart, and that's what's being appealed. And that's the argument I use, that Mr. Castelline cited that I did not cite authority, because I was following the legal theory asserted in Borum, which has gone up. PDR was filed, I think, in January of this year. So we're still waiting on the Supreme Court to rule on this. But then you get to the Arrington case, which is a Supreme Court case, and in that case, you have co-defendants breaking up with his girlfriend. There are 2 guns outside, one's a .22, one's a 9, and they shoot into the apartment, kill a 9-year-old girl. And in that case, there's a plea bargain, and under the plea bargain, it's a B1, but by the time it comes up, the legislature in 2012 has says, well, now you have to separate your B1 from your B2, and all second-degree murders are now B1, except these little 2 exceptions. And those 2 exceptions are the overdose, drug overdose, or the reckless, which is more like drunk driving. That's how that B2 has been applied. So if you're drunk, you kill somebody, you get the B2. If you give your friend drugs and he overdoses, you get the B2. But every other murder, second-degree murder, is a B1, and that's what happened here. That the court in Arrington looks at the facts of the case, and they looked at this shot from outside of the apartment that killed a 9-year-old, and they said, based on those facts, we know it was a B1 type of offense, not a B2 that he should be allowed to. And the Court of Appeals was overruled by the Supreme Court in Arrington. So I think you have to apply what Arrington says, is that you look at the facts. And the facts in this case is the defendant basically point blank pulled the trigger, because that safety trigger, it's not like you could drop the gun and it will discharge. You have to have positive pressure on this hinge trigger.
But Arrington dealt with stipulations to prior sentencing, to a prior record level, right, at sentencing. And the basic premise, I think, is that, you know, if you as a defendant stipulate to a particular class of offense for purposes of determining your prior record level, and there is in fact a statutory basis to support that then you're sentenced at the you know, it's determined to be the higher level felony, looking at the actual facts of the case. This appears to kind of be sort of the reverse analysis of that. Here we have a jury that was not asked literally or expressly to decide whether a felony is a B1 or a B2. The jury is simply asked to, based on the elements of second-degree murder, was this defendant guilty of second-degree murder under one of three theories. And one of the theories the jury found here was depraved heart. So at that point, it stops being a factual analysis. The question is purely one of law for a trial judge to apply the statute, right? Is this a B1 or is this, or should it be sentenced as a B2? And when the statute says, in this circumstance, if it's based on the depraved heart defense, it shall be sentenced as a B2. So I'm not sure what my ultimate question there is, but I guess the ultimate question is, does Arrington really speak to that? Or shouldn't we look more to the rule of leniency as it comes to sentencing in terms of, you know, sitting there in the trial judge's chair, you know, rather than an appellate court trying to rejudge the facts of the case to try and understand what the jury found and what it was basing its evidence on, you know, and sort of leaping back over the trial judge and his attempt to try and sentence this case, or her attempt to sentence this case.
Well, sure. I think Arrington, you're correct, this deals with stipulations. But the court specifically, if you compare the Court of Appeals opinion to the Supreme Court opinion, they're vastly different, because the Supreme Court looks at the facts. It gets into the minutia of the case to make the decision to say, hey, no, we're not going to give him the benefit of a B2. He's getting the B1 based on what he did. When the jury gets the verdict form, I have a copy here, they're just checking boxes. They don't know what's B1, B2, what's 20 years, what's 13 years.
Right, because that's the trial judge's job, right?
Yeah.
Right.
So for instance, when the jury acquitted of murder, they knew it was going to be life. So they were told that if you convict of murder in the first degree, which was a top charge here, he would have gotten life. And for whatever reason, they said no. But when they got to the second degree murder, they didn't know what they didn't know what the sentence was going to be. And actually, I approached the head of the appellate section, Dan O'Brien, about that issue. Would I propose a fix today here as to what can you, as the Court of Appeals sitting in judgment, how can this be fixed so we don't have to come here again arguing B1 versus B2, rule of lenity. Their appeal was based on an ambiguous statute. He readily admits the verdict is not ambiguous, but now he wants to change horses and say, well, it doesn't matter if it's an ambiguous statute or a big ambiguous verdict. Either way, you get to the same place. He wants a B2 for his client.
Well, let me ask you that question. Is it an ambiguous verdict?
No, I think you could find all three. There's sufficient evidence where the jury could have found that Monroe took out his gun, pulled the trigger 2 feet away from Lazarus's chest. But if they were to believe that, hey, maybe his finger wasn't fully on the trigger and maybe the gun was being slapped slightly by the victim, then it could be a depraved heart.
And so your position would be that the three are not mutually exclusive?
Not at all. And
So
that's
if
the end of my brief.
that being the case, and the statute saying that, you know, in the circumstance that the malice is necessary to prove second-degree murder is based essentially on depraved heart malice. Why then wouldn't, under the terms of the statute, the judge be required to sentence him to the B2?
Well, that's totally ignoring the B1, the two theories under B1. It's, you got convicted of these two high felonies.
Well, I mean, the statute, does the statute, I guess I'm sort of challenging the concept here, which is that, yes, the statute says, it's a B1 felony, except. And, if a jury finds 1 and 2, that would suggest a B1 felony, except for finding 3, which seems to fall right into the exception of the statute. So why would that not fall within the rule of leniency and require sentencing at the B2 level?
Well,
I mean, the jury wasn't compelled to find number 3.
no, they weren't. They sent out a note on the issue of second-degree murder malice, and there was a discussion of counsel and the judge as to what the proper response would be, and defense counsel just wanted a rereading of the malice, and that's what was done. The jury goes back, and they come back shortly after guilty of second-degree murder under all 3. So, when you have all 3, I think you have to look at the facts under Arrington. When you look at the facts here, it's clear this is B1 second-degree murder, and that's what the defendant was sentenced to, and that's how the sentence should remain. I don't know when the Court of Appeals, the Supreme Court's going to take up Borum, but that should add direction. There are other cases that have been entered since. Some of them are unpublished. And I think the reason why the Mosley decision happened was the Lail case, L-A-I-L, was pending when the Mosley trial happened, so the Mosley court didn't have the benefit of the Lail decision. But as has been said here, that Judge Holt did have the benefit of Mosley, and she contacted the UNC School of Government to get direction. She spoke to the author of that document to find out what should be done here. So there was a lot of research and consideration given before the charge was given.
Well, is it an instance where a trial court should be required to make findings of fact as to which of the theories are there? Or, I mean, it seems sort of, I'm struggling with that because we have the jury verdict, the ultimate finder of fact here. So.
Well, even after the jury came back, there was discussion in the record between defense counsel and the prosecution as to what the appropriate sentence would be, and Judge Holt said B1, and I guess that's why we're here. When I argued Mosley, after we got to that adverse decision, a decision was made not to appeal it, and it wasn't appealed, and I guess we're living with that decision. So hopefully I don't see you in 4 years.
You're welcome back anytime, sir.
I may be retired by then. If you have anything further, I'll...
Judge Carpenter, if you have anything.
No, I'm good. Thank you.
Great. Thank you, sir. We'll hear about our Mr. Casterline.
I just have a couple of comments to mention. I think that I guess following up that juries weigh facts, juries determine facts, and that's there's a lot to that, but it's also that a defendant on trial is part of his right to process is to know what facts and what the implications of a jury finding facts is at the point of trial. And that's why I think we can't just look back and have an appellate court sitting on high saying, well, this evidence seems more consistent with this. Because a defense counsel may have presented a case differently, may have argued a case differently to the jury. If the jury verdict was, if the verdict sheet looked different, we'd be arguing about. One of the reasons we have that charge conference on the record, one of the reasons we have the verdict sheet gone over by counsel prior to submission is the jury is so that we know what is at stake and what's happening at that point in time. And at the point in time that this jury goes out and they're given this instruction, I think that the prosecutor says doesn't seem happy with the instruction on the B2 theory, but says we'll leave it in the discretion of the court, that doesn't object to the verdict sheet. That's the case that went out there to that jury. And the fact that we come back here and we have some ambiguity, we have no clarity about what the appropriate sentence is, I guess, really the fault of the legislature. And again, what we have is an age-old doctrine of law applied by our Supreme Court as recently as last year that says when there is that ambiguity, we construe it in favor of the defendant. And I think that that's what it really means in this case, is that it's not clear that there's some merger. It's not clear that we look at the facts, and I understand the state would like to argue these facts are more consistent with the B1 type of second degree, and I could argue all day that they're more consistent with the B2 second degree murder. But the problem is that a jury looking at the facts found both, and they're not exclusive of each other. And the question for courts is how to resolve that. And I think that consistent with the traditions of our law and jurisprudence, we resolve that in favor of defendants, and we need to resentence as a B2. And again, I cannot emphasize enough, this is not just some minor ambiguity. It makes a difference of years in a sentence, years. And when we have that level of an ambiguity in something, again, we need to resolve it in favor of the defendant. And that's all I have at this point.
Mr. Castellano, let me ask you, just on that, you said it made a difference in years, but Mr. Monroe is going to be in jail for a while under either a B1 or a B2 theory, and so I guess would there be any harm to your client for this panel to wait for the Supreme Court to make its decision in Borum before issuing an opinion?
Well, I probably, in preparing for this, recognize that probably the Borum decision will probably be the guiding force in one way, and I assume they're moving with the speed that whether the difference between the best possible sentence as a B2 and the sentence as a B1, I think that we'll have some guidance from the court in Borum well before either of those things would be implicated. But we think that Mosley remains the controlling law. The state elected not to appeal that and all of that. But I can't meaningfully argue that we would be prejudiced by waiting.
Thank you, sir.
Makes sense. Thank you.
Thank you.
Thank you. And thank you both for your excellent arguments. Appreciate your time and answering our questions here today. With that, we will proceed to our second case. We will pause for a brief moment in order to allow our clerk to switch over the recording and to allow everybody to kind of switch positions. Thank you again.